versus Renell Reed.
Nimish Ganatra for the people.
And Assistant Public Defender Emily New on behalf of Renell Reed, who is in custody. Mr. Reed, can you please state your name?
Renell Reed.
Sure. What are we doing?
And Your Honor, we are trying to reach a resolution in this case. I have spoken with Mr. Ganatra. He does need some additional documentation from me, so we're asking for to adjourn this PCC in the hopes of resolving this case at the next one.
2-3 weeks.
2 weeks, please. And Your Honor, may I please address bond in this case?
Go for it.
So Your Honor, what we're asking for is a 1,010% bond. Mr. Reed has been in custody since June 22nd, so about a month. The guidelines I ran put him at 0 to 6 months. So realistically, this is not a case where he is facing additional jail time. Most likely, whatever the resolution, probation is the most likely outcome in the future. I think the most important point I want to bring up to the court, which is new information, from what I imagine you heard last time, is that Mr. Reed's family has fully moved out of the apartment where this incident is alleged to have taken place. This is a neighbor dispute type case, not domestic. I confirmed with his partner that they moved out on July 15th. They turned the keys in. I have that new address for the court. I can provide it in the chat. It is in Inkster. So there is no risk that he would have any accidental encounter and need to go near that area where the no-go zone is. And so I think a GPS tether as an extra precaution might be the most appropriate thing in this case. That way it ensures court appearances. He would have no reason to go anywhere near the no-go area since he has moved. He's a father of 3. He's the primary breadwinner. It's a 1-year-old, 5-year-old, and 11-year-old. He works at Amazon. He's worked there for 3 years. And as of today, he does still have his job there.
Response.
Your Honor, I have a slightly different scoring on the guidelines. I have 0 to 9. And I understand counsel's argument about likely sentence, but I would share with the court a few other bits of information about the defendant. There's a pending Ypsi Township case, malicious destruction of property, 200 to 1,000. I don't know if counsel was aware of that. It wasn't brought up during her bond argument. That's pending. There was a bench warrant at the time that I think the case was last in court. I would also say the state of this case is that the defendant was living in the apartment building where the victims were living and was constantly going to their place, sometimes opening up the door without permission, unlocked door without permission, complaining about the noise.
I'm not going to have the defendant interrupting the motion, and I'll just take care of it right now. I know what's going to be said on it, and motion for bond reduction is denied. Bond will continue. You're not going to have him interrupting while you're trying to make an argument. Made a very cogent argument, Ms. New, but he needs to keep his mouth shut. Thank you. Calls the case. People versus Simeon Davis.
Good morning, Your Honor. Amy Reiser appearing on behalf of the people.
Michael Gaddy, Assistant Public Defender on behalf of Mr. Davis, Your Honor, who is present from the jail. State your name, Mr. Davis.
Simeon Davis, Your Honor.
Doing
Your
on
Honor.
all 5 matters for court.
Yes, Your Honor. Ms. Reiser and I have had some discussions about this matter. I don't know if we'll be able to resolve it. It was a matter that she's only recently kind of taken over. If we could maybe adjourn this, I know it's unusual, but maybe adjourn it a week so that her and I can discuss it, and I could be heard.
I'm not going a week. I can go 2.
Okay, thank you, Your Honor. And if I could be heard on bond.
You can go ahead. Yes, to bond.
Your Honor, Mr. Davis has been in the jail for some time now. This kind of started with one arrest, and then these other charges came while he was in custody. He had been screened. He has been found competent. He is a resident of the area. He could reside. Last time I did confirm that he could reside with his son in Taylor. if released, he could be placed on a GPS tether to ensure, or house arrest even, to ensure that he not violate any of the parameters of the court, of any conditional bond orders to protect the community and to ensure that he is where the court wants him to be when the court wants him to be there. I don't believe he's a flight risk to other states or jurisdictions. I believe he's a long-term resident of Washtenaw and kind of southern Wayne County. So I'd ask the court to consider releasing him under those parameters. When I score his guidelines on the highest grade charge, I get 011 on the guidelines for that. I'm aware that there are several other charges, but they are not as serious grade wise anyways.
Response.
We would ask that the bond remains set where it is. This case, the defendant does have a relatively lengthy criminal history out of Hammond, Indiana in 2018 for trespass, resisting in 2020, trespass and mischief in 2020. In Michigan, attempt UNP of 2009, disturbing the peace in 2010, a DWLS in 2010, retail fraud 2019. He had a CSC out of Detroit that was dismissed in 2021. I don't know the facts of that case, but I certainly will try to find out. And he had a trespass in 2021. And this case involved the defendant being taken to psych ER and essentially just raining like hell on the employees there, like assaulting a female nurse, grabbing the genitals of a male nurse and telling him, I guess I'm gay now, throwing semen on one of the nurses, exposing himself while he was there. And then at some point he must have been released, because then on November, those offenses occurred October 14th, October 16th of 22. And then on November 7th, 2022, there was an employee working at building a hotel off of State Street. And on surveillance, the defendant is seen coming up to the building, pretending he's sweeping at like 2 a.m, then finding a brick, breaking into the employee's van and just stealing everything from it, including a knife, a work knife, coming back and slashing the tire. And again, then when he's taken into custody by police, he's acting as if, he's kind of passing out in the back of the car. So they have to take him to the ER where he's evaluated. He again exposes himself in the back of the vehicle to the police and at the hospital and resists arrest. So I think he is a danger to the community. And I don't even know what the bond is set at in these cases, but we would ask that it remains set where it is.
Bond reductions denied. Bond will continue.
Thank you.
See you.
I'll waive the formal reading. My client stands mute.
Defendant having waived formal reading, standing mute. Court will enter not guilty plea.
Judge, I understand that the prosecutor is requesting a tether. My client is not opposed to proving his sobriety and taking and testing. However, we would ask the court to consider an alternative to the tether, because he is a mechanic and he works with a lot of chemicals. And he was just explaining to me how the other day he was removing a gas tank from a vehicle and about 1.5 gallons of gas spilled on him. And I have had experience with clients before where if they get alcohol-based products on their bodies and on their clothing, it can cause false positives. And I don't want to have that happen with him. So I would ask the court to consider.
Well, but it's only going to look like a drinking event if he drank the gas.
Well, I think even
when they run it through the bottles, it's not going to look like a drinking event. I mean, I'll take that into consideration, Councilman.
That's fine, Your Honor. I've had clients before that worked in paint booths, and the manufacturer recommended against it in those instances. But that's our only concern, Judge. It's not proving his sobriety. So we would either ask for a sober link or a random ETG testing. And
all right, you want the pretrial adjourned?
We'd ask for the pretrial to be adjourned, Your Honor. We're going to have him screened for sobriety court, see if he's a good candidate for that.
I'll adjourn the pretrial to July 16th, was it?
We have the second.
We also have a second. Well, if he's going to get screened, he's in Saline. So actually he might qualify for ours. So let's do July 2nd, 2025,
Judge, I'm gonna be out of town that day.
July 16th,
Thanks.
2025, 9 a.m. As to bond in this case, Ledge BAC,
0.13, Your Honor.
Your Honor, if I may, it was 0.137 and 0.134.
accident,
Your Honor, no accident. He was pulled over for speeding 30 miles per hour over the limit.
all right,
He does have a prior OWI from 2022.
he has a prior.
Yes, Your Honor. For those reasons, that's why we were asking for the scram.
Anything else you want to say before I set bond? No.
No, Your Honor.
All right. Bond will be set in the amount of $15,000 personal recognizance bond. All other standard conditions, including no assaultive behavior or possession of any weapons. You understand that, sir?
Yes.
There should be no possession or consumption of any alcohol, recreational marijuana, or any illegal drugs. I am given the prior in this case, and we'll monitor it, and I'll hear argument if there is a problem. But I am going to order the defendant be placed on a scram tether. And you'll need to report to community corrections within 24 hours. So it might be best just to do it before you leave this facility because they're right over there.
Okay, thank you.
Okay.
Nimish Ganatra for the people.
Good morning, Your Honor. Assistant Public Defender Calvin Hawthorne, appearing with and on behalf of Kamu Carter. Mr. Carter, will you please state your name?
Carter.
Okay, what are we doing?
Your Honor, we have been in discussions with the people to reach a global resolution. However, we are still awaiting new charges to be authorized, so we are requesting a 2-week adjournment.
2 weeks? 2 or 3? His other case, the other case before me that I think is all part of this, I can't recall what date I gave from my other docket, but
It was the 2nd, Your Honor.
the 7th? That's
The
what I
2nd.
thought. 2nd.
Yes.
Okay, I could set it for the 3rd if you think you'll wrap it up, or I could set this for the 10th. Either way, what do you want me to do?
Let's go with the 10th, Mr. Ganatra. Is that?
All right.
Your Honor, I do have
Hang
one
on a second.
request.
Hang on 1 second.
One's on the 2nd, one's on final settlement on the 11th.
Okay. He also has, if you're looking for a global resolution, he's got one before me on the 2nd. He also has another that's set for final settlement conference before me on the 11th. So, all right. And we'll try to figure out a date. Yes, Mr. Ganatra, you were saying something, sir.
Your Honor, I wanted to bring to the court's attention, you're aware of the child abuse case and the domestic violence case, because both of those matters are being prosecuted by my colleague, Caitlin Kirby, in your court.
Yes.
Ms. Kirby informed me yesterday afternoon that the defendant is still having phone calls with the victim on the DV case, telling her not to come to court and appear. At this point, I'm asking for this court to revoke his phone call privileges in the jail on all the cases.
Any response, Mr. Hawthorne?
Your Honor, I would ask that you admonish Mr. Carter to refrain from making any calls to the victim and allow him to make calls to our office for legal purposes.
All right. Here's what I'm going to do. With regard to the probable cause conference, I'm going to set this one right in between that. I'm going to adjourn this out to August 10th, 2023 at 9 a.m. With reference, so his bond on this will continue. With reference to his phone privileges, you got. I'll certainly have a hearing on it if, Mr. Hawthorne, you think it's required, but in the interim, because of the nature of the other 2 cases that I'm familiar with, I am going to revoke the defendant's phone privileges. If you wish to request a hearing on that, you may, but at this point, his phone privileges are hereby revoked.